Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about the Curative Proviso. Cases that should have gone to the Supreme Court of Canada, but didn't. In Canadian law, if a person appeals a judgment, and the appeal is successful to the extent that there were legal errors or problems identified in the judicial reasoning that led to a conviction, but no substantial wrong or miscarriage of justice occurred, i.e., the person was obviously guilty and would have been convicted anyway in the opinion of the appellate court, then they can apply something called the Curative Proviso. This essentially says that because there was no miscarriage of justice, that the trial was fair enough even though it was wrong, and even though the reasoning that led to the decision was wrong, the appellate court can accept the original judgment despite the legal errors. To me, this is a problematic provision in Canadian law, and it's actually inconsistent with some of the ways that we've seen administrative law deal with problems in appeals. For example, in Vavilov, the Supreme Court of Canada noted that if the pathway to the decision is demonstrably unreasonable, where there's a manifest flaw in the reasoning or an error in the reasons related to the judgment that ultimately led to the conclusion that was reached by the tribunal, then even if the conclusion was capable of being supported by the evidence in the record, the decision itself is unreasonable, which is actually higher than some circumstances of the application of the Curative Proviso, where evidence may establish guilt, notwithstanding legal errors in reasoning that led to findings that didn't impact the substantial fairness of the trial, despite the fact that the way that the judge rendered the decision was wrong, or the way that the judge admitted certain pieces of evidence was wrong. And it always seems like the court is looking back at the actions of a trial and doing their own reweighing of the evidence and their own assessment of the evidence in order to determine whether or not the Curative Proviso applies, which is really quite outside the role of a court sitting on an appellate level. So the rule has never sat well with me. Which brings me to the case of Mr. Frigon, who challenged the Curative Proviso in the application of his trial, essentially raising the question before the Supreme Court of Canada about whether or not this is really something that should be applied in the circumstances of his case and more generally in Canadian law. And the Supreme Court of Canada denied leave to hear this issue. But certainly the Curative Proviso is highly problematic. And it's also almost impossible to challenge because you can't raise it in your trial and create the correct record for a constitutional challenge. It can only be raised at the appellate level where you don't really raise these constitutional issues. It is troubling that we have a provision in the criminal code that allows a conviction to stand even though the evidence was admitted that shouldn't have been admitted, or even though the reasoning was applied that shouldn't have been applied. And yet, here we are. The Supreme Court of Canada had an opportunity to perhaps limit the application of the Curative Proviso only to the clearest of cases, where it was so obvious that no other conclusion than guilt could have been reached, rather than to engage with this sort of reweighing of evidence that Mr. Frigon was alleging occurred. And it's unfortunate that we don't see more constraint of this provision in our Canadian judicial system. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.